From the court standpoint, it is, it's a cliche, but it's the end of an era. I mean, he's been there a long time, and he's really helped to shape the court in the time he's been there. I did an analysis a few years ago of some of his First Amendment opinions, and the catchphrase that I came up with was pragmatic populist. He's definitely a guy who is interested in the real-world effects of opinions, interested in how ordinary people are affected by the law. For example, in the First Amendment area, he's been a guy who has often given a lot of consideration to whether speakers without great financial means are going to be able to participate in public debate. But in order to sort of further those interests, in order to advance the interests of ordinary people, he's very focused on what is this decision really going to do. He's not a guy who writes something, let alone for a majority, just to make a point or to put on a show. When he first joined the court, he was junior for a very long time, most or second most junior, and in those years he became known as quirky, as sort of a maverick, as someone who was very, very smart, had interesting ideas, but really did nothing to try to forge coalitions around his ideas. A lot changed really beginning in the early 90s. I mean, it was a gradual progression, but eventually, in the year that I clerked for him, 1994, he became the leader by virtue of seniority of the court's more liberal wing. Justice Blackmun, who was kind of in that camp, had retired. And so Stevens was in the position, is very practically significant, the position of assigning majority opinions where the liberal bloc sort of prevailed against the conservative bloc, which was typically led by Chief Justice Rehnquist. So he was suddenly in a position where he had to lead and he had to think strategically, and he adapted to that role brilliantly and became a very respected tactician and also a guy who became known for exactly what he hadn't been known for before, for being able to put majorities together behind difficult positions. He knew the court very well by that time, and I think he rose very deliberately to the role of being somebody who was going to have a significant effect. So on a practical level, over the last certainly 15 years, whenever the sort of liberal wing of the court has done anything significant, either getting majority behind a controversial opinion, his finger or dissenting in some significant way, his fingerprints have been all over it. One that he will be remembered for a long time is the opinion in U.S. term limits versus Thornton. Back when term limits was a big political issue, this case came before the Supreme Court. May a state limit the terms of national legislators? And the court, in a very heatedly divided 5-4 opinion, said no. And it ended up being a big statement about federalism and the nature of national unity. So that's one that's going to be remembered for a long time. He wrote the majority opinion in Reno versus ACLU, which is the landmark internet free speech case, a case that still stands as the cornerstone of the court's and the federal judiciary's approach to speech on the internet, a ringing endorsement of open discussion on the internet and a serious slapdown to any kind of major effort to regulate or constrain speech on the internet. He also, a few years ago, co-authored with Justice O'Connor a really significant opinion in a campaign finance case, the McConnell case, which upheld the most important elements of the McCain-Feingold campaign finance law. That law and that decision is in the process of being dismantled by the present Supreme Court. So as a practical matter, the influence of that opinion is going to be waning. But I think that pendulum will swing again, and when it does, the opinion that Justice Stevens and Justice O'Connor wrote in McConnell is going to be the sort of philosophical template for what I hope will be a return to greater allowance by the court for campaign finance regulation. Talking about dissents, Bush versus Gore has clearly, I think, overtaken everything else. It was a very rushed and confused process, I think, for all the justices getting that work done. But Stevens, out of all of the dissenters, I think, managed to come out of that process with the most emphatic, ringing denunciation of what the court was doing in Bush versus Gore, what the majority did in Bush versus Gore. And Stevens was never a harsh author. He was never caustic in his tone. But I think for that reason, when he was impassioned and when he was angry, his general persona of, calm and reasonable, hard logic but not hard rhetoric, I think makes his words stand out. And that's certainly the case in Bush versus Gore. It was a really strong rebuke to what the court did in that case. It was a joy. He was brilliant. He knew his job very well. He was, as a boss, just on the most simple level, there are two kinds of bosses. They're the kind who pass their stress on to their subordinates and the kind who absorb it all themselves and protect their subordinates. And he was the epitome of the second kind. The buck stopped with him. Here was a guy who was incredibly busy, incredibly powerful, incredibly important, and he didn't act like any of those things were true. I mean, he didn't put on false airs like, oh, I'm just some guy, but at the same time, he never threw his weight around, and he always had time for us, for his clerks, even when he had a lot going on. And seeing someone at that level do things so much in the right way, I think, you can't see that and not want to try to live up to it in your career. And so, it's do what whoever does. I mean, for me, professionally, do what Justice Stevens does. Try to be as much like him in just the way I carry myself, the way I conduct myself as I can be. And it's a losing battle because I'm not him, but I think the effort makes me better